Okay, good afternoon, everyone. So I think most people are here now, but a few more may filter through, but we'll make a start anyway. So thank you very much for joining us today. A lovely day, and here to talk about Brexit. What more could you want? So for those of you that haven't met me before, my name's John Pickervance. I'm a partner here at Forbes and head of the commercial team. I'm going to focus today on speaking about some of the commercial law implications of Brexit and what we can do surrounding our contracts, and maybe looking at our intellectual property portfolio too. And I'm joined by my colleague Amy Stokes, who is a senior associate in the employment department and specialises in business immigration. So, at the risk of sounding like Chris Whitty, please can we have the next slide? Okay, so Brexit, where are we at? We're pretty much where we were about a year ago, if not longer ago. We've had numerous delays now and numerous put-offs, and as far as I'm concerned, the government has had something of a free pass this year with what's been going on with COVID. But nonetheless, we are where we are, and we're presented now with a period of 6 to 7 weeks before we get to 11 p.m. on the 31st of December, when everything changes. So at the moment, I think given that we are down to 6 or 7 weeks, we are looking at no deal looming large, which obviously means a hard Brexit and the implementation of certain tariffs and barriers coming into effect, which no doubt you are all familiar with. We are at least, however, looking at a 3-stage implementation, which at least in light of COVID, has given us a little bit of leeway in terms of businesses making sure that they are ready and can delay some of their declarations up until at the very latest July of 2021. I must stress, however, that that is going to be subject to some very specific circumstances, and also provided that you do have a very good compliance history with dealing with customs and the applicable authorities. So what I would always recommend you do in that context, in the context of making your declarations, is take specific technical advice, both from those that specialise in making the customs declarations, such as your local Chamber of Commerce, for example, and in particular where they've got an international trade specialism. I can recommend the East Lancs Chamber having a very large group in that regard, but also taking advice from your accountants or your tax advisors, to make sure that you're fully aware of the implications on VAT, duties, imports and the like when you are making those declarations. In addition to those advisors, we are becoming more aware of some software solutions which are available on the market. Some of our clients are actually also developing such products at this present time. So it's going to be a useful tool, particularly for those of you who are perhaps doing less customs declarations on an annual basis than others, to rely upon some of the support which is out there. And indeed, if there's any of you that do wish to be put in touch with some of those that we have contacts with, then I'd be more than happy to facilitate that. So no doubt some of you will have made certain preparations, others perhaps more so than others. But we'll just do a little poll at this stage. So Gabs, if you could please pop that poll on screen. It may take a moment or two to appear, but it'd just be great to get a feel for what position you're all at in the Brexit readiness procedure. So you'll hopefully see those on screen now. Right, so we can see now in varying different levels that certain of you have taken steps, which is great to see. Some more so than others, that we can see from the second question, and that people aren't necessarily very confident as to the opportunities which are presented by Brexit. So with that in mind, we can at least hopefully give you some good takeaways today on the sorts of things that we can do to mitigate what those challenges might be. Amy will run through some of the implications of business immigration, but I'm going to talk about the things that we can do within our commercial contracts to make sure that we're as ready as we possibly can be. So there aren't any wholesale changes to the law that we're going to see necessarily. Oh, sorry, Amy, I think we've just skipped ahead there. just due to the fact that we have a raft of UK implementing legislation in place, that we have common law or case law, as you may hear it, that's entrenched in English law and has been for long predating the point at which the EU was even formed, let alone the UK joining it in some cases. And also we're looking at what we call retained law as being the legislation which has been readily prepared, which will bring into effect the EU law, which we're going to keep in force in the UK come the 1st of January. So that's all going to come into effect at that point. So there's not a massive divergence there that we'll see. We do think it's going to be a good opportunity for the UK to review certain pieces of legislation as it moves forward. Think about the commercial agents regulations, for example, that is founded on EU legislation and that many people will be familiar with if they do use agents overseas, particularly within the EU. And again, the vertical agreements, block exemption that we see governing vertical agreements, such as those with your distributors, for example. We've got, at the moment, obviously, singular regulation within the UK and the EU with regards to your products. There's certain criteria which must be met in order to sell those on the market. What we're going to see, obviously, is parallel regulation if you do continue to trade with the EU. So be aware that whilst it may not change dramatically on the 1st of January, we are likely to see a divergence as time goes by. So a need to continually keep that under review and make sure that you're familiar with what's being required of you in your products. So if we can move over to the next slide, please. Okay, so looking at now the impact on contract law itself. So I've mentioned common law already briefly, and this is really what contract law is actually founded upon in England and Wales. So due to the fact that, as I mentioned, it's been here for a long, long time, there's very minimal impact on contract law. And I'd stress that's contract law. Amy will go into employment and immigration. What we do, however, see is that because case law is so well entrenched, and businesses in particular do have the autonomy to trade as they wish and to enter contracts in such terms as they wish, and we're talking here about when they're trading with other businesses, then they will be bound to the wording of the contract. Now, what a court won't do is look back at the point at which that contract was entered into and think, well, did we know Brexit was going to happen when we entered into this contract? Ultimately, a business is deemed to have the efficacy to enter into a contract, whether it becomes a good or a bad bargain at some point in the future. So just be aware that you'll have very, very limited, if no relief under common law, if your contracts all of a sudden become a bad bargain for you or you're adversely affected by Brexit. However, what we're looking at here is that the impacts are likely to be felt on the substantive obligations which are on the parties. So what do we actually mean by that? Well, substantive obligations for you may be to pay for the goods or the services, or they may be as the supplier to deliver goods of a certain quality, of a certain standard in accordance with certain regulations, or maybe by a specific date. So they are the things that we are likely to see being most heavily affected by Brexit, no deal, or whatever the consequences are. So do make sure you review your contracts to make sure that you've got the flexibility within them to take the steps that you need to avoid being breached on the 1st of January or in the immediate period thereafter. Finally, on this slide, it's a question we also were commonly asked at the sort of early stages of the pandemic back in March and April is the contract now impossible? Is it effectively frustrated? So we have this thing called the doctrine of frustration. Now, this is very, very difficult to rely upon because in order for a contract to be impossible, it has to be actually impossible to perform any of the obligations under it. It's not that it's now very, very difficult, a bad bargain, all of a sudden you're generating a loss by performing the contract. It has to be physically impossible or illegal, for example, to actually perform the contractual terms. So I note the parallels there with COVID, because even in those circumstances where parties were locked down, in some cases businesses were closed, it wasn't impossible, just very, very difficult to perform those contracts. So it's even less likely to be something that you can rely upon in the circumstances that present themselves with Brexit. Okay, so looking now at the contracts themselves, and in particular some of those clauses that we might see being affected more readily. So first things first, what I would do is I would open your contract and have a look for any references to the EU, to EU laws, to their standards and regulations that appear throughout the contract. The reason we need to do that is because obviously Brexit could raise questions on the meaning of those references. So the EU all of a sudden doesn't include the United Kingdom, for example. So if you're granted an exclusive territory within the EU to distribute someone's products, for example, then all of a sudden, does that actually include the UK anymore? Well, no, it doesn't. So we need to make sure that the contract's updated to account for that. With regards to references to legislation, standards, regulations, we need to make sure that there are sufficient clauses in that contract to make sure that those references are automatically updated. So you'll recall me mentioning that retained law earlier. Now that will be sufficient if there's a clause in your contract that says any references to law will be as superseded or updated from time to time, or something to that effect. If you don't have something in there that does that, then all of a sudden, all your references to EU laws, standards and regulations may well be outdated and irrelevant. So the contract really needs to be looked at very carefully. As you're aware, there are tariffs and duties which are going to come in and that will apply to many goods that are imported or exported. So do consider whether or not you need to make any calculations as to how your prices or your payment terms are actually dealt with in relation to those. And also, whose responsibility is it to actually pay those goods, tariffs and duties? If perhaps you've got something in your contract that deals with that, then that's fine. You shouldn't be too badly affected. But if not, then obviously you need to think about that. One way of doing that very effectively is via the use of Incoterms. Those that trade internationally may be familiar with Incoterms, but what we've got here is basically an international standard set of terms that are used throughout the world. So Incoterms is international commercial terms, and it will specify who is responsible for preparing goods for import or export, who is responsible for dealing with the paperwork, who's responsible for paying the duties, and also things like delivery and risk. So if you've got those in your contract, great, but only great if you've got the correct Incoterms specified. So do make sure you carefully look at those. We're also likely to see some currency volatility as we have done at each stage of the process so far. So do make sure again that your price and payment terms are flexible enough to cover this. It might be, for example, that if the difference between the pound and the euro, for example, moves by more than X%, then that enables you to revisit your prices. That's something we've built into some contracts for some parties. Alternatively, do speak to your foreign exchange advisors and make sure that you are covered as far as you can be in that regard to hedge against any risk. And I do give a disclaimer at this stage that is not financial advice because I'm not regulated to give that. So moving on, please. Looking now, I suppose, at the promises and assurances that you give with your goods and services. And again, obviously, this can always be in the context of you purchasing goods and services, but just speaking for ease from the perspective of you delivering these yourselves. In the context of the first bullet point, when we're talking about warranties, we're not talking about a period of cover here. So a bit like a part going on your washing machine within 12 months, but we're not talking about a warranty in that sense. When we refer to warranties here, we're talking about contractual promises. So a contractual promise, for example, that the goods and services delivered under the contract meet certain criteria. So maybe they comply with EU laws. Maybe it's CE markings, for example. You do need to make sure that you carefully look at those warranties to make sure that you're not tying yourself into delivering something that you might not be able to control post-Brexit or post 31st of December. Obviously, we need to consider the impacts on your supply chain, depending on where you are. This may be upstream and or downstream. In particular, looking at delays and the border checks which may or which will come into effect on the 1st of January. Ensuring that those tariffs have been paid and that the requisite standards are met for the goods and or services in question, obviously goods in the sense of border checks. Current studies suggest that there's something around 40 to 70% of lorries that aren't going to be ready. Now, I appreciate 40 to 70% is quite a large bracket there, but even in the best case, almost half of lorries won't be ready on the 1st of January. And by ready, we mean that they aren't going to be carrying the right paperwork. Maybe the paperwork hasn't been sent through in advance in the correct format or standard. Now, this means that all of a sudden you may be liable for delays to your customers if perhaps you're using raw materials in part of your products, in part of your manufacturing processes. So check the contracts for things like time of the essence. If you see the wording time of the essence, then that means that ultimately if you're as much as 1 second late on delivering, then that is deemed to be such a fundamental breach of contract that the other party can terminate it. So do try and avoid time being of the essence where possible, unless obviously you're imposing this on your suppliers and it really is of the essence. It might be, for example, that you need to flow down certain contractual terms from your clients. Now that may give an automatic right of termination, but there may also be weaker rights of termination. For example, if you fail to perform a certain obligation by a certain date and you fail to remedy that within a specified period, then again, that may trigger the right to termination. Make sure you check that. And again, liquidated damages. So what we see with liquidated damages is that if you're delayed or late in performing, if your goods don't meet a certain standard, then you may well be paying a penalty of X% or a certain fee per day or per week, perhaps, until such time as you've met that condition. So do make sure that your liquidated damages aren't too draconian, or that you completely carve out any Brexit related impacts that may lead to you being in breach of contract. Okay. So looking at a few more types of clauses that might be affected. Force majeure, again, it was something very commonly asked of us at the time of COVID. And unfortunately, in many cases, it didn't cut it back then. It's even less likely in the same case as frustration to cut it when it comes to Brexit. And by cut it, I mean excluding you from performing your contractual obligations, excluding you from liability, where you're in breach as a result of the consequences of Brexit. Force majeure isn't necessarily recognised in English common law, which means that you need a contractual clause in there to make sure you can rely upon it. And the more general force majeure clauses will state that you're excused from performing your obligations where an event takes place that's beyond your control. Now, many people will say that, well, I don't control Brexit. I certainly don't control whether it's going to be a hard Brexit or a soft Brexit, whether it's no deal or what that deal may look like. However, force majeure does assume that the event that's beyond your control is something that couldn't reasonably have been foreseen. And clearly that's not the case with Brexit. This has been going on now for a very long time. And notwithstanding that you don't know what type of Brexit we're going to be faced with, you do know there is going to be a Brexit of some sort. So force majeure isn't something you're going to be able to rely upon. Brexit trigger clauses are great because whilst we can do all of the other things that we've mentioned there, and I would recommend you do those anyway, what you can do is you can insert specific clauses that define what Brexit is, what adverse effects you may experience because of Brexit, and what that will then excuse you from being in breach of under a contract. So it may give you a grace period for delivery times, for example. It may allow you to increase your prices. It may simply allow you to terminate the contract and go your separate ways. This is ultimately your best fallback to a bad Brexit, basically. Looking at dispute resolution now, at the moment, it's very easy to enforce an English law contract and one which is subject to the jurisdiction of England and Wales, the courts which are based in those jurisdictions. It's easy to enforce that within the EU at the moment due to the treaties and conventions that we are a party to as the UK. This is going to become slightly more difficult post the 1st of January, and obviously given that there is no precedent as to how those contracts can be enforced, even if you obtain that judgment in the English courts, we need to consider some alternative options. And a good fallback or a good alternative option is to implement what we call a multi-tiered dispute resolution clause into your contract. And this is what we advise clients do when they're trading with third countries, i.e. those outside the EU. It means that we can use mediation bodies, it means that we can use arbitration bodies which are internationally recognised, such as those provided by the International Chamber, and it just means that you're much more readily able to enforce your contract because you're using a body which both countries recognise and use. Finally, data protection and GDPR. There's been obviously a lot of noise about GDPR since it came in a couple of years ago. Fortunately enough, this is EU regulation in itself. We do already have the Data Protection Act 2018 in place, but it does need to be sorted such that we are using that retained law again, so to speak. But note that the law won't change because of the things I've mentioned. It's already EU law. We've already got that implementing legislation in the Data Protection Act 2018. And we already have the adequate levels of protection on each side of the channel in that case, or the Northern Irish border, which means that the EU and the UK alike is satisfied. But we just need to make sure that that retained law comes into force and what it looks like. So moving now swiftly onto intellectual property, much more straightforward, looking firstly at your registered trademarks and designs. What you may or may not be aware of is that you can register trademarks and designs in the UK itself or in the EU more generally as a unitary registration. What we have at the moment is a system whereby once the 1st of January is reached, we will be granted a comparable trademark in the UK or a comparable design in the UK where we hold an EU trademark or design. So you don't need to do anything, essentially, if you hold an EU trademark or design. Also, if you have an international trademark, you'll be aware that you need to designate a home territory from which that international trademark was registered. If that is the EU, if that home territory is the EU, then that will be redesignated to the UK if you are that UK body. And again, you'll be granted that UK right if you've used that EU trademark to get the international trademark thereafter. If you've got an application that's currently going through with the EU IPO and it's not finished, then you've got 9 months to apply in the UK to get the same protection. But we would at least like to hope that anything which is currently in the offing would get done before the 31st of December. And also we are saying make sure to get your applications in quick, because if you want to apply directly to the EU IPO post 31st of December, then you will need to use an EEA-based attorney and not me. So moving on to copyright. This remains unaffected, fortunately enough, due to the UK's continued participation in international treaties. So nice and simple on the copyright front. For those of you that are unfamiliar with copyright, this essentially protects the expression of your idea. It might be a literary creation, an artistic one. It may be a design, a specification, maybe some software coding, something like that. So that should largely remain unaffected, which is good to know. And finally, from me, for the time being, do check your license agreements as well. This may not be a straightforward intellectual property license. It might be a wider distribution agreement or manufacturing agreement, for example, within which certain intellectual property rights are licensed to you. Maybe you're reselling someone's goods under their trademark. maybe you're manufacturing under specification, for example, you need to make sure that the rights you're being granted do actually still apply in the UK and are valid here too. And also, if you're granted exclusive territories, or if you're granting exclusive territories, then make sure that that is very clear, and that you don't simply use that broad brush term, the European Union, if you also intend for it to include the United Kingdom. So that's all for me for now on commercial. We'll pass on to Amy for business immigration. Thank you.
Thank you, John. So as John mentioned, I'm going to be speaking to you now about the changes, the huge changes to immigration legislation that will come into play in January of next year. In addition to that, I'm going to take you through some of the views that we have about what potential changes to employment legislation will be following on from Brexit, if any. And I just kind of wanted to start with a poll. So if Gabs, if we could put up this this poll to start off with, just as a kind of, just to get a benchmark really in relation to what you guys are doing. So I'd be interested to know how, so does your organisation currently employ EU nationals? Does your organisation currently employ migrant workers from outside of the EU? Do you intend on employing EU or non-EU nationals post-Brexit? And then finally, does your organisation currently have a sponsorship licence for sponsoring migrants from outside of the EU? So if we could just take a couple of minutes, just to, well, a minute or so, just to have a look at that and answer that, that'd be great. Okay, so quite a few of you employ EU nationals currently, that's 78%. There is only one of the attendees who employs migrant workers from outside of the EU currently. The majority of you intend on employing EU or non-EU nationals post-Brexit, and there is one of the people on this session who have a sponsorship licence. So thank you for that. That's quite reflective of some of the wider surveys that we've been doing as well. So so yes, so moving on to, I'll start off with the kind of future immigration changes. There was a paper that was set out by the government on the 13th of July of this year, which has clarified what the new UK points-based system will be. Unfortunately, the immigration bill is still continuing its passage through Parliament, nothing like something a bit last minute when it's due to take effect on the 1st of January of next year. But it is very clear from the guidance that we have that this bill will reflect the guidance that we've received so far. So the information that I'm going to give you on this is taken from the guidance, and we don't anticipate there to be any changes, but we are awaiting the absolute final details and the final guidance, because at the moment it is particularly complicated, the guidance that is on the website, on the government websites, and they are planning to simplify that somewhat, which will be helpful for everybody, not least me. So the focus is really going to be on attracting the highly skilled and skilled migrant workers into the UK. And the plan is, well, it will treat EU and non-EU citizens equally. And it's aimed to attract those that can contribute to the UK economy. So the common travel area, that's going to remain. So that means that Irish citizens can continue to enter, live and work in the UK as they do now. So this was to resolve the Irish border issue somewhat. Second point really is that there is going to be no route, and this is a key point, there is going to be no route for low-skilled workers. Previous work done by those low-skilled workers, that the intention is that that will be done by the resident workforce, and they'll say that otherwise it will be no longer required because of greater efficiencies and automation. I mean, that's the plan anyway, but let's see what really happens. There is a list of eligible occupations that for those that can take advantage of the points-based system. That's on the government website, but there are some specific exclusions from that. The cap on tier 2 general workers, which there is at the moment. That's going to be suspended. So tier 2 general workers, that's the current route for skilled workers into the UK, non-EU nationals into the UK. There is a cap on that at the moment. That's to go. That's going to mean that there is no limit on the numbers of skilled workers as long as they meet the requirements. And what they're anticipating is that this change alone is going to reduce the end-to-end process for sponsoring skilled workers by up to 4 weeks. Currently, it's not a straightforward process at all. It tends to take a few months in order to get that into place, but they are putting various measures in place to reduce that period. So they reckon that this will reduce it by 4 weeks. The salary threshold, and that's going to be subject to the going rate for each occupation, but that's going to be reduced to 25,600 per annum. And there's also going to be various trades for those jobs that are on the shortage occupation list, or PhD students in particular subjects where lower salaries than that threshold can be earned. This will make a bit more sense when I go into the specifics of the points-based system, but there are various ways of obtaining the requisite number of points, and the salary threshold is one of the key ones. So it is pretty high, and that is set to dissuade some, particularly in more low-skilled roles, people bringing migrants over. The other really key change, and this is a very welcome change because this is one of the parts that makes current sponsorship of non-EU nationals very difficult, is that there is going to be no requirement for a resident labour market test to be pulled together before somebody is sponsored, and that will apply to anyone with a tier 2 general sponsor license. And what it currently means is that you have to essentially advertise to settled workers any role for a period of 28 days before a migrant can be recruited. And this will also mean that it will save employers time, as they'll no longer need to document this evidence, because normally you'd have to document that you'd advertise this and send it over with your application for sponsorship, with your certificate to apply for a certificate of sponsorship. That reform, they're saying, is going to remove a significant amount of time from the end-to-end process. But there is still going to be the requirement that sponsors will have to fill a genuine vacancy that meets the skill and salary thresholds of the new route. And you cannot create roles solely to facilitate immigration of a specific migrant into the UK. So some more immigration changes. So this is one of the exceptions to the skills requirement. There is currently this seasonal agricultural workers scheme, which has been a pilot so far, and that's going to be increased to 10,000 workers per year. So that there will be the ability to bring workers over in agricultural roles who are unskilled in that way on a temporary basis to help with harvests and all this kind of stuff as well, because that is crucially where a large number of the EU nationals that they currently service that area quite heavily, and there was some significant concern from the farming industry of the impact on them. So they are keeping that under review, that 10,000 number, and they may increase it depending on whether or not there are any issues of shortages in that area. There is going to be no route for the self-employed. They should use the startup route or the innovator route. So if they're looking at starting up or investing in a business in the UK, then they can use that route. It's going to be a different route in that way. So they'll have to demonstrate that they meet the requirements from that. And in addition to that, and this is something for those of you who currently employ foreign workers who are already residing over here and will continue to do so, but from the January 2021, most EU citizens will not need to attend a visa application centre to enrol their biometrics. They'll be instead able to provide facial recognition images using smartphone. There's like a smartphone self-enrolment app and a form that they can use. And they won't need to, this is part of a kind of longer term vision for overhauling entirely the visa requirements for travellers as well, using this kind of biometric facial recognition by way of a smartphone. So that's part of the longer term vision of the government. They also want to ensure, and this is another route that some of you who want to continue to employ EU nationals or non-EU nationals post Brexit, there is going to be, they want to ensure that they retain the best students, the government do going forward. So they're launching this graduate route in summer 2021. So that we've got a bit longer to wait for that one, but it's to coincide with the end of the current university year. And that's going to allow those who have completed a degree at a UK higher education provider that has a track record of compliance to stay within the UK for a period of 2 years after they've finished their course, or 3 years for PhD graduates. And they can, crucially, they can work at any skill level, and then they can switch into work routes if they find a suitable job. So a lot of the more savvy clients that I'm working with at the moment are looking at that as a route for kind of bringing in talent from universities. You have them for 2 years, you develop the skill set in that way, and then you can sponsor them at the end of that, that 2 years on the highest salary and in that skilled route. So it's an interesting way of looking at things if you do want to continue to employ people and from abroad and retain that skill. So kind of concentrating now on this points-based immigration system and the changes to that. So this is the tier 2 skilled workers route that we're looking at. There are some mandatory requirements. So the requirement is that that an employer, in order to sponsor somebody, you have to have a sponsorship license to start off with. So you'd have to apply for that. You can't, you know, there is a route for going through that, and that's something that we can help with if you want to continue to employ EU or non-EU nationals or bring them over, those who don't currently reside here. You will need to get a sponsorship license, but you need this number of 70 points. So there is mandatory requirements, and those will account for the first 50 points. So the first of those is that there is that they have a job offer, and that job offer is from a licensed sponsor. And then the second is that the job must be at or above the minimum skill level. So that is the level of A-level or an equivalent qualification. And the importance there is that that is the job needs to be at that level, not that the individual has to have that that qualification. And that was a question that was asked the other day, actually. So as long as the role is at that level or equivalent, that is sufficient. There are lists of occupations on the website that I mentioned before. They've listed everything that is suitable, and the job roles and codes and things like that as well. And then in addition to that, the applicant must speak English to an acceptable standard. There are various requirements for what that is, and those are out of scope of today, but if you have a question on that, then I can deal with that. Then we have the tradable points. So there's an additional 20 of these that are required. So the first of those is that the salary level, as I mentioned before, should be the greater of, so the higher of 25,600, or the going rate for their particular job. So they have listed on the website, and it's quite interesting just to understand what the government are considering as a benchmarking for particular roles. They've listed pretty much every role that you can think of, and what they say the going rate for that job is. So you've got to, so in order to get the extra 20 points, you've got to pay at that rate. There is an exclusion to this because they want to encourage new entrants to the UK labour market. So those who are switching from a student or graduate route to the skilled worker route, those who are under the age of 26 when they apply, or those who are looking for working towards a professional qualification or moving into a PhD, their requirement is actually 30% lower than the figures on here as well. So they don't need to earn that amount. It is reduced by 30%. So that, and they will benefit from the reduced thresholds for a period of 3 years. So those are requirements for that. So that's helps quite a bit there if you're bringing in new entrants to the market. The other way of getting 20 points is to have a job offer in specific shortage occupations. So there is a list of, and you've probably seen in some of the press, that things like ballet dancers are shortage occupations. Equally, it's things like mechanical engineering, a lot of the engineering type roles, and a lot of tech roles, and tech experts will fall within that specific shortage occupation. There is still the requirement to pay a minimum salary requirement of 20,480 for those people, not the higher level. But if you pay them that minimum amount and they have a job offer in a shortage occupation, then they will get that 20 extra points. And then the alternative, and I think this is going to be slightly more rare, but this is to have a PhD relevant to a specific job as well. So that's more for your scientific or technical jobs. There is a route for getting the extra 20 points that way, but again, the minimum salary requirements still apply. So you've got those three different ways once you met the mandatory requirements of getting that extra 20 points to get the 70. So how are we preparing for this? So if you believe that you do need to employ migrant workers from the 1st of January, that's from within or outside of the EU. So this is just for new migrant workers, not those who you're currently employing. You should apply now for sponsorship. I'm dealing with clients at the moment who are going through that process of getting the sponsorship license in place, because it does take quite a few weeks, and the process for doing that is relatively complicated as well. So if that's something that you want to do, then get going with the sponsorship license and putting everything in place for that, so that as at the beginning of next year, you can start looking for migrant workers. But then you can allocate your certificates accordingly, and we can advise on that if you need assistance with that. The really key one as well, and I'm sure most of you here who work in HR, who employ, I know a large number of you do employ EU nationals, you need to ensure that those EU, EEA or Swiss employees apply to the EU settlement scheme for settled status, and you need to obtain evidence of that as part of your normal right to work checks as well, that they have the right to work past that period of time. So the deadline for this is the 30th of June 2021. So it's the employee who needs to apply for this, and their family as well. They need to apply for settled status before that deadline, and you'll need to obtain evidence of that as well. If you are impacted by any potential shortages, you need to look at how you're going to attract different staff or different sources of employees, and how you're going to retain the current staff as well, because I know that there are certain areas, particularly in hospitality and potentially in the agriculture and manufacturing realm, and obviously in the medical professional, through nurses and support staff in that way, that will be very heavily impacted by this because of the reliance on currently EU workers and nationals. So ensure that you're retaining those employees that you have, and looking at ways in which of filling those gaps if you need to at that stage. So that's all on business immigration. I've just got a couple of minutes before we move on to questions. So if you have any questions while I'm talking through this, if you want to pop those on the Q&A, John and I will pick those up at the end. I know John's probably looking at them at the moment and thinking of some of the answers. But I just wanted to take you through a little bit about kind of the predicted changes to employment legislation. I know John has spoken to you a little bit about from an international trade perspective and IP, but in terms of employment law, we're in a very similar situation to John in the basis that a lot of the laws and the rights that we have are very heavily entrenched in English law currently, but there are a number of the pieces of legislation that we have derive from EU legislation, and a lot of the cases, the EU cases, a lot of the case law that we rely upon is EU case law as well. So there is likely, from the employment perspective, to be some changes. There'll be nothing immediately, but certainly over time, I think there is an appetite to revisit some of these less popular areas and less popular pieces of legislation that we'll deal with. So I've just put a couple of points on there. I've already dealt with freedom of movement, so I'm not going to go into that in any detail. And with equality rights and family rights, I don't think that any government or any going forward is going to suddenly say, I'm going to repeal discrimination legislation or rights to equality. I think that or family rights either, that would be hugely unpopular. Going forward, it's likely that those will be improved somewhat rather than changed in a more negative way. But in terms of TUPE, I think that currently there will be some changes to the current legislation on that. We have gone further than the normal than the EU legislation, because TUPE derives from EU legislation, in that we have protection for service provision change. So if you're changing contractors, that there is protection for workers through that process, and that goes further than the EU legislation. But one of the most unpopular parts of TUPE, the first is that if there is going to be a TUPE transfer from one employer to another, you have to elect representatives unless you are a micro business, so you have a business less than 10. Then if you've got a couple of employees transferring over, this is quite an unnecessary and difficult process to elect these representatives. So I think there is the potential that will be withdrawn. In addition to that, there are significant restrictions on harmonisation of contractual terms of contracts of employment post TUPE transfer. So you have to have various different business reasons, or it's unconnected with a transfer, which is very, very difficult. And I think that will be eased slightly as well. In terms of other changes, so the working time regulations are hugely outdated, and those of you who work in HR who are on this call will know that we have a huge number of holiday pay cases that are mainly EU cases or derived from EU cases, and these relate to payment of commission and bonuses during holiday. And I do think that that it is likely that the working time regulations and these holiday pay cases will be completely overhauled essentially, and we'll start again with that, and they will produce. This has been on the agenda. I know this has been on the agenda for some time to sort, but other things have taken precedence, so there'll be certainly some changes post Brexit relating to that. And then again, equally, the agency workers regulations, they derive from EU law and are hugely, hugely unpopular. And it is likely that they will be repealed and changed in some way. So that's the key point there, is that after 13 weeks of being an agency worker on an assignment, they have the same rights as normal employees. And that's just something that employers find very, very difficult, and it is unpopular. So I think that will be revisited certainly going forward. So that's all from me. If anybody has any questions now, John and I will just have a quick look on the Q&A. John, I think we've got one for you there.
Speaking on mute there, Amy. Yeah, I think there's one for me on the Q&A and one for you on the chat. And obviously we've got a couple that came through prior to the session as well, which we'll touch upon. So firstly, does a contract that references the EU mean that a UK business has no right to distribute in the UK? What we need to do there is we need to really look at what the reference actually says. If the reference to the territory is merely and very simply to the EU, then unfortunately that means that the EU, the reference will not include the UK any longer. Sometimes what you see is a contract that says the European Union, which is comprised of obviously the countries as at the date of the contract, and as are supplemented and or removed from time to time, for example, which will obviously keep it up to date as it refreshes. But obviously that merely keeps who is in the EU up to date. It doesn't include those that are booted out or choose to leave. And in this case, you would need to make reference to the UK on that contract to avoid being in breach of it. So yeah, it's one of the main issues which we're seeing with contracts at the moment is reference to territorial restrictions. If it refers to the EU, then that is the EU as at the date on which the contract needs to be enforced, unless it says otherwise. Okay.
Thanks, John. And I've had a question, which is what visas would be required if taking people for internships from another country? And I think that very much depends on the basis of the internship. So if it's an internship on the basis of study, so it's linked with a university. So if you have an internship as part of a university degree or a course, there are different types of visas. There are the student visas that an employee would be coming over on initially. You would need to ensure with the education provider that is that is bringing that person over and they're working with you, that they have the correct visa. They would likely obtain that type of visa through that education provider, but you need to ensure that they do have the specific right to work, and it's not just a pure education visa in that way. There will be routes, absolutely will be routes for students to come over and to do these kind of sandwich courses or internships as part of that, but you just need to make sure through the education provider that they have the correct type of visa. If it's an internship in a different way, so if it's with a education provider, say in the country in which the migrant resides, you would probably need to sponsor in that way or link up with the education provider. I think it would be much more difficult to do it in that way. You'd likely be required to go through the tier 2 skilled worker visa in that way. It would most likely have to be through a UK education provider if you're bringing an intern in that way. There is a route for voluntary routes, which is the tier 5 route, and there are different requirements for sponsorship during that, but you do need a sponsorship license if you're bringing somebody over on a voluntary basis. So if you have a voluntary internship, then there are rules and requirements for the sponsorship in that way, but it's a different type of sponsorship license. So hopefully that helps with that question. Have we got any more questions while you've got us here? A chance for a bit of free advice, everybody.
I've got one more, which was just asked in advance of the session, and what are the implications for e-commerce? Not quite as straightforward, this one. I suppose with e-commerce, it tends to be that you're selling on a B2C basis. Most people that buy from a website are consumers, although not exclusively, appreciate. Which means that there are consumer rights that you need to take into account. Obviously, those are nice and clear in this country. They are founded on the consumer contracts regulations, which gives everyone that cooling off period when they purchase whatever it may be on the internet, receive it, decide that they want to send it back, and also the Consumer Rights Act. The difficulty you have when you're trading with consumers is that whilst you may specify that English law applies, it's often the case that the consumer has their own rights within their own jurisdiction, and you will always need to take those into account wherever they may be. So obviously that can change drastically from one country to the next. I would suspect that it's fairly consistent throughout the EU, but obviously we can't confirm that because there are so many different territories, and obviously we advise on English law. But in terms of supplying of goods, if you put consumer rights to one side, whether you sell it on the back of a purchase order quotation, on the web or not, it makes no difference. Ultimately, you're still bound by the import and export restrictions, the requirement to deal with customs declarations and the like. So do make sure, obviously, your contracts are as robust as they can be in that regard.
I had another question, which was asked prior to the event as well, which was, what evidence do you need that an employee has applied to the EU settlement scheme? And I mentioned that needs to happen prior to the 30th of June. You have to hold evidence of the right to work within the UK. So, and there is this right to work checker, the online checker that you can use to ensure that is the case. But you still need to ensure that it is covered in your contracts of employment, that employees are to provide you with that right to work. And if there is any change in that status, they must advise you. And you would be required, if you had a Home Office visit or there was some issue with the right to work, you would be required to hold evidence that you have at least conducted the electronic check, and I would be discussing with your employees and ensuring that they keep you in the loop about their application for settled status, and they provide you with evidence of that. So the advice there is to ensure that you have the correct evidence. Great, unless there are any more questions. Oh, I can see another one. Is the one come up on the Q&A? John, have you picked that one up?
Yeah, I'm just having a read of that one now. So we currently have licenses. So the question is, we currently have licenses granted to us from a sister company to use the EU patent in the UK. Is there anything we need to change post 1st of January? I think with that, what we would need to do is actually have a look at the license agreement itself, just to make sure that the terms, first of all, were clear enough as to what's meant by that. But also, secondly, you will need to have a look at the actual patent itself and the registration. We don't strictly advise on patent law. That's something that we tend to speak to patent attorneys about. However, to the extent that it's covered in the form of a license, then we can certainly advise on that. So if you'd like to send that across, then I'd be more than happy to have a chat with you about that.
Great. I think that is all the questions now. We've come neatly to the end of the session. We do have a survey that Gabs is going to now put up on the screen, and we'd be grateful if you could fill that in. We have various different events that we're thinking about putting on, and if you have, it would be really helpful to us if you could fill that part in. And if anybody has any additional events that they're interested in, please do contact us afterwards. We do take your feedback into account, and we do tend to put on events that people ask for. So if there's anything you're particularly interested in, then please do let us know. And so thank you very much for joining us today. I've certainly learned a lot from John. It's always good when you do this with somebody from a different team. And you've got our details, and we'll be sending around these slides afterwards, so you'll have a bit more information. And if you have any questions, please do drop us the line. Thank you.
Thanks very much. Thank you.